Yeah, it is an absolute honor to welcome Judge Andrea Galhardo Palma, a distinguished civil judge currently serving at the Sao Paulo State Court, where she presides over the Second Regional Corporate Insolvency and Arbitration Court, covering 29 industrial cities. With over 2 decades of judicial experience, Judge Andrea has overseen thousands of cases involving contracts, torts, corporate law, construction, and public contracts, and has played a pivotal role in arbitration and insolvency proceedings in Brazil. Judge Andrea holds advanced legal qualifications from the University of Sao Paulo, the University of Pennsylvania, Columbia University, and is also currently pursuing a PhD in business law at the University of Lisbon. She is a fellow of Chartered Institute of Arbitrators and an active member of several international legal and arbitration bodies. We invite Judge Andrea to share her valuable insights in the area landscape in Brazil and to contribute to today's discussion. The floor is now yours, ma'am. Ma'am, I think you're on mute, ma'am. Judge, I think you're on mute. Kindly unmute it.
Oh, sorry. Okay, again. Good morning, everyone. It's a pleasure being here. I think this is an amazing event. I would like to say, first of all, thank you to the Iba Javan. I don't know if I spelled your name correctly. And Bajavan could organize us around the world and to stay together. And because we are fellow from CIR, it was a little bit easy to find us. So, and I'm so glad to be here. I will share a little bit thoughts about Brazilian overview of framework regarding arbitration, but let's say a little bit more about my my position here, because I'm not arbitrator and not lawyer, but I'm a judge and at a specialized court in São Paulo, and we deal with challenges regarding arbitration. And also, we are court of the assistant in arbitration proceedings for example, seizures or to notice or force testimony or for hearings and so on. We are, or for enforcement also. We can cooperate with the arbitral tribunal during the arbitral proceedings, and also after arbitral award, we can serve as a court of the enforcement and also for challenges regarding annulment and so on. So I will address a little bit how, for example, São Paulo structured this specialized court. But I want to say first that Brazil is, like Colombia, is a civil law country. And we have a one constitution, federal constitution for all states, one federal civil law procedure for all states, and also civil and criminal code, and also arbitration federal act for all states. So it's a little bit easy organize judgments for judiciary and for lawyers understand how the judiciary works, and also it's a little bit easy to harmonize our judgments and precedents and so on. Regarding precedents, these come from the federal superior court, and we call Supremo Tribunal Federal, and also in federal level that discuss issues regarding federal law, we have Superior Court of the Justice, and also the tribunals around the states, and like São Paulo, that is a second ground of or appellate courts for the state of São Paulo. I'm a member of the first level yet, but the final stage in a specialized court, and after me we have the São Paulo, the tribunal of the São Paulo appellate court. So that's this framework, and I will address a little bit more during my presentation, but I want to say that nowadays Brazil is the second country that has the number of the arbitration. First one, United States, and the second one, Brazil. This is a good thing for us. It means that Brazil has been increased arbitration because not only the arbitration federal act is good, but it's because the judicial courts can enforce uh, arbitration in Brazil. So we are a friendly court for arbitration. It's not for coincidence that ICC create in few years ago a department in Brazil, in São Paulo. They have an office in São Paulo, and we have many chambers of the arbitration chambers for domestic international arbitration, not only in São Paulo, but around the state, but mostly São Paulo, Rio, and I want to say Kansas CBC, Fiesp, and another small chambers, and also chambers that deal with insolvency and arbitration we have. It's nowadays is a very important place for arbitration. But we have some problems. I will address this a little bit. But first of all, my agenda here in this event for you is give you an overview about arbitration framework and how Brazilian law treat public and private entity participation in arbitration, some key trends and developments that we have nowadays, and how the role of the judiciary regarding arbitration, and how many cases we can enforce or deny or annul in Brazil, especially in São Paulo, which is rare, but some cases had a strong, let's say, commotion because it was big cases, and so, but it was important that because courts only intervene in that situation that is a big problem or gross violation of the due process of law or the duty of the disclosure and the duty of impartiality, independence, and only in a rare case. So in addition, I will address some current challenge and critical issues regarding arbitration. So I think I can pass this. If I have any problem regarding my PPT, I will ask some help from the Shakti prior. I want to say thank you, Shakti, for your support in this organization, let's say.
Sure, ma'am, sure.
Okay, let me share this screen because let's see. I'm not fine this for sharing. If you can share for me. I don't know if you have this.
Just a minute, ma'am.
Because I'm not.
We are sharing from our side, ma'am. The screen is being shared now.
Yes, because okay. Let's go on to the overview, please. I think it's the third chart, because they are not
Currently, the
enough.
slide is on the overview of Brazil arbitration, Judge.
Okay. Hmm. And, it's not working from my computer, sorry.
Sorry to interrupt in between, ma'am. Is it not working for you, ma'am?
No, it's not working.
Is your presentation not visible on the screen for you, ma'am?
It's not work. It's appearing, but I don't know how can I pass for you.
Ma'am, the thing is like the control of the presentation is with us. As and when you need to change the slide, you just intimate us in order to change the slide and we'll change it.
Okay,
Yeah,
but
ma'am.
can you go on to the overview of arbitration framework? It's
Ma'am,
a little bit.
it's that slide itself, ma'am, that is present, if I'm not wrong.
Sorry.
Ma'am, it is the same slide, the overview of Brazilian arbitration framework, which is
Okay,
being
okay,
shared.
okay.
Yeah, ma'am.
So nowadays, since the Arbitration Act in 2096, and our Supreme Court has decided in 2001 that this law was constitutional. And after that, this law, which is based on, in ancestral principles, but not only ancestral, but also French law and also Spanish law. And after that, the institutional arbitration has increased in Brazil. And after 2001, in 2002, Brazilian has adopted the New York Convention also, and so which was important for recognition of the international arbitral award. Today and since 2002, this role is to recognize the international arbitral arbitration award is competence of the Superior Tribunal of the Justice in a federal law, which is a proceeding that is not take so much. And I cannot, for example, decide about the recognition of the International Arbitration Award only this federal level in a superior court has the power to decide about it. And regarding the organization of the after recognition in 2015, superior federal court of the justice recognized also the principle of the competence, which means that the arbitral tribunal has the first competence to decide, first prima facie, the competence to decide his own competence, and also the validity and the effectiveness of the arbitration agreement. And after that, the courts in all levels and all states has been using this principle, for example, to deny lawsuits or challenges at the first place without going to arbitration. So it's very important. Which Brazilian Arbitration Act decides that court has the narrow intervention to the arbitration proceedings. We can cooperate mostly, and also we principle in the first place, for example, for in a, emergent measures or urgent measures before the constitution of the arbitral tribunal, and during the proceeding, as a court assistance for seizure or to decide about the collect assets or to stay contracts or without intervene on the merits, just for urgent measures. And now in São Paulo, for example, we can give urgent measures to anticipate evidence only in a narrow situations that, for example, the position of the witness has any problem regarding issue or personal issue, or, for example, the own health or the risk of the lose this evidence, and has to be crucial, or to justify that the court can anticipate the decision from the arbitral tribunal. It's rare also, but for example, sometimes the risk of the lose this evidence justify anticipate the evidence, but we can confront this evidence during the arbitral proceedings. That is our framework. Another narrow provision that the Brazilian arbitration law has is the annulment. We have a few grounds of the annulment, but for me it's a huge ground, because it's 8 grounds of the annulment. We can annul if the part violated the due process of law, or the tribunal violated due process of law, and the tribunal has lack of the independence or impartiality, or break the rule of the duty of the disclosure, and the arbitral exceed the power regarding the arbitral convention, and also when the tribunal is corrupt, or any criminal situation during the arbitral proceedings. And also when the arbitral, because it's not from the law, but it's a precedent, when the tribunal exceed the power and decide against the public policy in Brazil, in a substantial situation, or in an evidence, let's say, decide issue that is not arbitrable according our legal framework. So, regarding the trends nowadays, is very interesting, because Brazilian has, after 2015, Brazilian law has amended and allow arbitration in a public sector. I don't know if you know well, but Brazil is a big market for oil, gas, infrastructure, and energy. And these kind of contracts normally comes from the public sector, government, and regarding contracts of like PP contracts or concession. And nowadays, in a federal level and also state level, government, public entities can make a contract with the arbitral clause, and this kind of the contract and the proceeding is very interesting because it's the way that confidentiality has a little bit flexibility because of the public interest in that contract. And also some arbitral institutions have been rules regarding the arbitration in a public sector also is very interesting. They're using also, for example, construction and other tools in that contract that dispute boards before arbitration in a contract. Some states that use contracts with the arbitral clause in the public sector also put in a clause of dispute boards for this kind of the contracts, and mostly because the investor investor before giving money ask for this kind of the clause in a contract. So another interesting trends that have been occurring in Brazil is that our law nowadays allows that interface harmonically between insolvency proceedings and also arbitration. We adopted in insolvency law the ancestral model law on cross-border insolvency. And this law says that if the parties in arbitration proceedings goes to the insolvency, arbitration proceedings can continue. We don't stay arbitration proceedings, and also we don't interfere in a validity and the effectiveness of the arbitral clause, which is very important for parties and also for business in Brazil. But our law, insolvency law, said that we don't interfere. Arbitration and insolvency can continue. But if the subject matter of the arbitration is payment, compensation, or has a huge impact of the assets of the insolvent party, that can be a risk if the arbitration can continue, because always issue regarding payment, compensation, transaction that has impact in arbitration in a insolvency process, the court of the insolvency has the power to decide. So, an example, if the part discuss compensation and wants to make a payment during the arbitral proceeding, or discuss this issue regarding the essentiality of this payment, and and the arbitral tribunal does not stay the proceedings, this arbitral award can be annulled by judicial court, the court of the insolvents, because the court of the insolvents, after the insolvency proceedings, or after the initiate the insolvency proceeding, say that only courts can decide about payment. All assets, all rights regarding payment, and organize this payment regarding not only one creditor, but regarding all creditors, to protect them. There is a principle that in insolvency law that say equal treatment regarding all creditors. That's why if the subject matter in arbitration is a new credit, or payment that's new credit in advance, this payment in advance is not is prohibited, and the tribunal, arbitral tribunal, it's not allowed to make this happen. I don't know if I'm clear about that, because this issue is complex, especially for studies, not for students, not for practitioners. But nowadays, court has been decided that arbitral tribunal has to be or has to take this in account for decide if the arbitration can continue or not. So regarding the judicial support and enforcement, there's some issues in Brazil that is a complication regarding this, because going to the court is a little bit cheaper in Brazil. And what is happening now is that most after arbitral award, most part of the parties don't pay or don't comply voluntarily the arbitral award. And so they use the courts, judicial courts, for enforcement, which is not good for us because we are overwhelmed. All states, all judges, but they use this as a strategy to avoid paying in payment and gain time to use this in the future as a strategy. And also they use the challenges as a strategy to avoid payment in advance. So this is our vision that is not and critical point that we can discuss. We have been discussing in our court and also with the arbitral community, because lawyers goes to the court in a frivolous ways to avoid payment after arbitral award or to comply with the arbitral award voluntarily. They use courts to gain time. And so this is a critical point. Another critical point that we nowadays is facing, that our arbitration federal act in Brazil has the same clause that say that the arbitral tribunal or the arbitrator has the duty to disclose the relevant fact that can jeopardize your independence and the impartiality, and also jeopardize the arbitral award. And because this article in our law, Article 14, is so broad without any specification which kind of the 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 fact should arbitrator review, né, or make this clear. And also most arbitral institutions don't have this checklist as IBA guideline has, and sometimes this is a big issue, and some lawsuits come to us to decide if the arbitrator violated duty of disclosure or not. And some institution now has some checklists regarding some questions that arbitration should to answer if they have any problem with, for example, another the lawyer of the parties, and they if they have the kind of relationship they have, and so on. But I think, for my personal view and also the court view, that they have the power of the arbitral community and also arbitral institution to make this clear, has a checklist of objective arbitrability, also objective facts that they can disclose, and like IBA guidelines. But the Brazilian Arbitration Committee is a organization, also creates some considerations that arbitrators can use for as a guide for disclosure, but it's not only a recommendation. It's not something that can oblige arbitrations to follow. So I think also some current challenges, regarding current challenges and critical issues, because these flaws in our legislation and the use of the judicial court as a instance to enforce the arbitration or to decide about annulment, arbitral community sometimes say that there is a big judicial activism in specific cases and regarding arbitral proceedings or arbitral cases. So sometimes this happen, I think, but it's rare, and some case has a big impact in arbitral community. But especially in São Paulo, the number of the annulment is irrelevant. They use judicial court to go to ask for annulment, but in a 99% of the case, let's say, we deny these lawsuits, so these challenges. So, but some cases that are gross violation of the duty of the disclosure, or also the violation of the uh, um, uh, arbitration agreement, we decide in a rigorous on way, and there is a big impact in all community. The last critical judgment was that in insolvency issues, that Superior Court of the Justice decide that compensation, it's compensation during the arbitral proceedings is prohibited if the part is insolvent. You can discuss the new credit, the new right of the indemnization or new damages, but you cannot make this payment, or you cannot effective this decision if the party is insolvent, this power is the judicial court of the insolvents, because the public order and the mandatory law of the insolvency in Brazil. I think that I address the most important framework in Brazil. I don't know if you have any questions regarding that, but what I can say that according to Professora Selma Lemes, one of the drafters of our law, Brazil is the second place in the number of the arbitrations. So I think we is because we as a judge and courts, we enforce arbitral award a lot, and the annulment and the enforcement is also a power of the judicial court, unfortunately. But we dream that arbitrator parties in arbitration can uh, can respect the arbitral award and comply with voluntarily, but it's not happening nowadays. So I think I give you, I don't know if in a clear way. Sorry, because sometimes my English is a little bit rough, because I don't have been using a lot as a professional, and sometimes to change the links is a little bit difficult today. But and let me know if you have any questions, and I hope I can uh, stay with you another time discussing about arbitration and also the perspective around the world. If you need anything from the judge from Brazil, let me know, and I will glad to serve you and to give our overview regarding arbitration and also the court assistance in arbitration proceedings. Thank you all.
Thank you, Judge Andrea, for the bird's eye view, what I can see from a judge having a pro-arbitration approach. And we are very happy on behalf of KFCRI. We are indebted to you for this wonderful presentation and acceptance, first of all. And anyway, because of proximity of time, we have to just move on to the next speaker. Any queries, we will share to you so that you can leisurely get back through emails and we can convey to the audience. Thank you, Judge Andrea, for facilitating. Thank you.
Have a nice day.
Thank you. Thank you.